Judge, Mr. Schmidt has, I think as of yesterday, provided some more discovery. Some of it is on dist and some was...
Already, the judge is setting the tone. Facts only. No speculation, no emotional spin. In legal terms, this means the court can't rely on hearsay or allegations. Only stipulated facts. The details both sides officially agree are true. That's a big deal because it limits what can actually shape the outcome.
By email today, we have continued to discuss potential plea, although given the trial date and the preparation necessary, we're getting at a point where we have to end that process. In any event, I proposed an alternative plea to Mr. Schmidt probably a couple weeks ago, and he'll correct me if my timing is wrong, where same plea as previous, amend count 1 to second degree, plead to felon in possession of firearm with respect to the shotgun, amend the count that relates to possession of a firearm, that being a pistol, amend that to allege possession of the firearm that was found in the kitchen cabinet, which was the victims that hadn't been charged, plus plead to misdemeanor possession of firearm while intoxicated. Mr. Schmidt's reply was, I don't think the judge will go for that. Why should she go for that if she didn't go for it before? We've had further discussions. Actually, over the last couple of days, Mr. Schmidt and I have exchanged some lengthy emails. Mr. Schmidt did mention the additional discovery that I haven't looked at yet. I have to do that, obviously. And we had another discussion yesterday where Mr. Schmidt is contemplating amending count 1 from attempted homicide to first degree recklessly causing injury. And I think I responded to that with an observation about the enhanced penalty from the original charge of second degree recklessly causing injury with a firearm enhancer. The court, Mr. Schmidt and I agree, the court made a mistake in its decision. The penalty for second degree recklessly causing injury with a firearm enhancer, the enhancer adds 5 years to that. So
maximum possible penalty of 12 and a half.
12 and a half.
That's what I said, as I knew that.
Whoa, that's a massive downgrade. Attempted homicide to reckless injury? That's the difference between potentially decades in prison and something closer to a mid-level felony. But here's the twist. Prosecutors don't just reduce charges like this for fun. There's usually a reason: weak evidence, negotiation strategy, or maybe even an overcharge to begin with. What do you think? Fair adjustment or legal chess move?
Oh, well, okay, then,
I was well aware.
that isn't what we remember. In any event.
It enhances it from 12 and a half to 17 and a half. That was the correction.
I think that's
Okay,
what
so from 12 and a half to 17 and a half,
I think the maximum penalty for an F felony is 7.5 confinement, 5 years ES. The enhancer adds 5 years to the confinement portion, so it would be 7.5, 12 and a half confinement,
modifier?
5 ES. Firearm modifiers.
It does not. If the statute specifically says it does not increase it by any additional time if the underlying facts related to a firearm.
No, it says, so first of all, second degree reckless endangering safety is a class F felony. Class F felony is the imprisonment. You're right. It's 12 and a half years total.
See, I did
I
it
was
correctly.
mixing that up. So it increases it to 12 and a half.
Exactly.
What the court is saying though about the essential element thing, possession of a firearm or possession of a dangerous weapon or use of a dangerous weapon is not an essential element of recklessly causing injury.
No, but the underlying facts, what's the statute now? I don't have the modifier statute in front of me.
I don't have it in front of me either, Judge, but anyhow, you asked for the status. That's essentially where we're at. Mr. Schmidt and I are discussing. I met with Michael for just a couple minutes before this hearing. I've given him copies of the emails that Mr. Schmidt and I have exchanged. We're going to chat again. He's the one that ultimately makes the decision about this. My concern is, I don't know what your thought is with respect to potential penalty in the public's interest. I'm lost on that, Judge.
I don't
can't.
have a thought. My thought is, because I can't, as Mr. Schmidt said, we can't look at a case and we can't go, okay, well, we're looking at this many years initial confinement, and so we're going to charge based upon that. My thing is my job is to review any offer to see if it is in the public interest. And it doesn't mean a set amount of initial confinement years. It's just what was offered, the second degree reckless with the modifier, as well as one count of possession with of a felon with a firearm and one operating a firearm while intoxicated. When we have 9 counts, 8 of them are serious felonies. The plea agreement as proposed didn't meet the public interest.
Judge, you're relying, as I recall, in rendering your decision, you're relying on the allegations of the complaint, which I must emphasize are allegations.
I'm going to interrupt you. I relied upon the stipulated facts by the defendant.
This is the core tension: public interest versus plea deals. Judges have to balance justice and efficiency. Sure, a plea saves time and taxpayer money, but if the deal feels too soft for serious felonies, it risks sending the wrong message. Should the public's sense of justice outweigh the benefits of a deal? That's the dilemma right here.
That's what the court relied on, because I cannot rely on anything else. The arguments from the state, as well as the stipulated facts from the defense, and believe me, I use word for word what was taken down by my court reporter.
Mhm.
That's what I used. I didn't use any other facts alleged that were not stipulated by the defense.
we did not stipulate anything with respect to the charges that were going to be dismissed, because there is, Mr. Schmidt and I disagree about how a jury will receive this evidence, but there are facts to support a defense to the felon in possession of the firearms, where those firearms were found downstairs in a basement behind a closet.
Counts 2 through 8, or at least 3 through 8.
3 through 8, not 2. The whole plan is that Michael's going to plead guilty to the facts, to the crimes that the facts support. Certainly count 1 as amended to second degree reckless with the firearm enhancer. Count 2, possession of the shotgun as a felon. And now we propose count 9, which is the misdemeanor possession of a firearm while intoxicated. And Mr. Schmidt and I have talked about
That was already
something
included
different.
in the plea agreement.
I don't think count 9
was.
was, but
9 months, it was.
yes, okay.
I guess my take on what's happened since then is that was Mr. Harrington's proposal. I had proposed instead to him pleading to amended second degree reckless endangering safety at the dangerous weapon modifier. And then all of the felon in possession of firearm counts dismissed, but read in the intoxicated handling of the firearm. And then we'd run the count 2 and 1 concurrent to each other, and counts 3 through 8 concurrent to each other, because 3 through 8 are all the constructive possession ones. They're all in one location. They weren't using the commission of the crime. Count 2 was, which is why it's concurrent to count one. In the meantime, the reason why there's additional discovery is I started checking with law enforcement, since my take on what the court's written order was is concerned about all the felon in possession of firearm charges being dismissed but read in. So I started collecting evidence about what is our evidence for that. I discovered that law enforcement had not actually sent to us, the DA's office, some of the evidence to that. That's part of the 4 gigabytes sent there. In particular, photographs of what the weapons, how they were arranged when the police found them versus how they staged them later when they were taking photos for documentation purposes. We also have obtained photos of him handling the firearms in the past 5 years. We obtained those from the victim. That was actually just today, so I don't know if Mr. Harrington has that.
I haven't looked at that. I think.
And there it is, the evidence bomb. Fresh photos connecting the defendant to firearms could completely undercut his defense. In legal storytelling, new discovery this late in the game often reshapes negotiations or explodes them. The prosecution just strengthened its hand.
Mr. Schmidt has advised in the email yesterday or early this morning that that discovery was available, and I haven't looked at it yet. Handling the firearms in the last 5 years, I don't think that OWI conviction felony is 5 years old, though, is it?
I can look it right up.
It was 2022. I believe the oldest photo is 2023. But I have not looked at the photos myself. I'm just reiterating the summary of the photos from the investigator who told me about them this morning.
And Mr. Harrington, to answer your question, the court has to look at what has been charged with the agreement that's been extended when I'm looking at the public interest. I don't know anything about your argument that none of those firearms were even able to be in Mr. Winquist's possession. I know nothing. I go off of what has been charged initially with the facts that I have stipulated to and with what was stated in the arguments. I did not have either one state at the arguments that counts 3 through 8 could not be proven beyond a reasonable doubt in front of a jury.
And my position is there's a real question about that. There are defensible facts to counts 3 through 8. And my position always has been that Michael admits count 2 certainly, count 1 as proposed to be amended, and would admit count 9. Those.
Then it is what it is, and a jury can decide. You said that there are defenses. You can argue the defenses to the jury. The jury is the impartial body who looks at the evidence, who bases the testimony and determines credibility.
I know what the jury does.
Exactly. That's what it is. And if you are indicating that there are defenses to 3 through 8 possessions of firearms by a felon, when there have been no statements to the court that there were not firearms for counts 3 through 8, then you argue it to the jury.
That's the status of our negotiations.
All right, so I can understand, Mr. Schmidt, you offered to amend count 1 to second-degree reckless, plead to counts 2 through 8, dismiss count 9, but have some concurrent and consecutives within there.
Yes.
And Mr. Harrington made a counter offer of amending to second degree, again with the modifier.
I haven't agreed to second degree because Michael had,
Oh,
Michael and I
first
need to
degree.
talk about that.
Or reckless,
yes.
just reckless?
My current proposal is amend it to second degree reckless with a firearm enhancer as was in the original offer.
And was it plead to 2 possessions of a firearm
2 possessions of a firearm plus count 9.
plus the misdemeanor? So we have 2 offers out there, and so it sounds like the parties are trying to work to find an agreement that may be acceptable in the public interest, or we go to trial.
Yeah. And the one peculiarity with the defendant's offer is the second felon possession of firearm charges is the only gun I didn't charge because I can't connect it to him.
The count 8?
No, it's not charged. It's
Oh,
a
it's
gun
not
that's not
charged.
referred in the complaint at all.
Not even referred to in the complaint. So
That's
the
what
one
I'm
that
getting
cannot be connected to him, the one that was found allegedly in the kitchen that was perhaps owned by the victim, is not charged.
Yes.
Okay. See, now I'm having a better understanding of this case and the facts. as you stated, I have what is alleged in the criminal complaint, the stipulated facts by defense, and the arguments that were presented to the court at the hearing. That's all I have available to me to
That's the final fork in the road. Either they strike a deal that satisfies both the law and the public's sense of fairness, or they roll the dice before a jury. And as any defense lawyer knows, once you walk into that courtroom for trial, control is gone. What would you do here? Deal or trial?
determine whether or not the plea agreement is appropriate for the public.
And I do think the agreement I proposed is consistent with the public interest, the one I've articulated today with the additional counts.
All right, so that's where we are. We have the final pretrial September 4th at 1 o'clock. Are we looking at having a status or something prior to that, or we're just sticking with September 4th?
I would prefer that we have a status before that.
Your August 14th date? August 14th at 10:30, I believe you're coming back.
Yes.
August 14th at 10:30, we will have another status.
So you had previously suggested 9:45 might be available.
It is.
Maybe we do it 9:45? Because I already have 4 for 10:30.
Yes, we can do 9:45 or I can do 11:15.
9:45, please.
All right. 9:45.
Just, I'm sorry, Judge, I can't do it that day. 9:45, I already have plugged in some things, so I'll be here.
Or I can move it to the 11 slot.
No, 9:45 works.
All right. August 14th at 9:45. August 14th, 9:45, we'll have another status. Anything further?
No.
Not from me.
All right, then we are adjourned.